Thank you very much, Mitchell Epner, for coming on to Objections. And part of just wanting to get right into it, tell me about your background as a former federal prosecutor who has prosecuted sex crimes. We're at the end of week 1 of the Ghislaine Maxwell sex trafficking trial. Just tell me about your experience.
Thank you for having me on, Adam. It's a real pleasure and an honor. So from 2001 to 2004, I was an assistant United States attorney in the District of New Jersey. And from 2003 to 2004, my intake area included sex trafficking, child pornography, and involuntary servitude. So I was a part of some of the earliest sex trafficking prosecutions in this century.
And you led intake in the District of New Jersey for those cases?
So that was my intake area, which meant that basically any sex trafficking case that came through the District of New Jersey was going to end on my desk. And I worked closely with people from Main Justice in the Civil Rights Division, which is where the sex trafficking function is housed, and I've remained close with a number of the leaders of the anti-sex trafficking effort at Main Justice.
Now, how do the cases that you fielded back when you were prosecuting these cases compare to the ongoing trial of Ghislaine Maxwell?
Well, there are some similarities, but I'm going to start with the differences. The differences were that the cases that I was prosecuting largely came out of a very poor Mexican town called San Miguel de Tenancingo, where there was a cartel that made it its business to lure illiterate Mexican campesinas, most of whom were underage, some of whom were of age, telling them that they were going to be brought into the United States to work as maids and domestic servants. And when they got here, trapping them into sexual slavery. And rather than the very jet set world of Ghislaine Maxwell and Jeffrey Epstein, we're talking about women who were forced to engage in upwards of 10 acts per day, normally for very small amounts of money to the cartel and no money to them. So these were not women who had any real choice in the matter. They were lured in initially, but once they arrived here, they were deprived of all free will. In contrast, the Ghislaine Maxwell trial is about two of the wealthiest people that I've ever encountered. Jeffrey Epstein was, it appears, a billionaire. Ghislaine Maxwell, I'm not sure how big her fortune was, but her father was reputed to be a multi-billionaire before his death. And they were engaged in this activity, allegedly, for their own amusement. It was not a financial motive, as it was in the cases I was prosecuting. It was for their own personal amusement, and that made the cases much more akin to the anti-child pornography work that I also did when I was in the U.S. Attorney's Office.
Now, in terms of the, you had mentioned that these are both incredibly wealthy individuals. I remember when Jeffrey Epstein was first indicted, I asked the U.S. attorney, is Jeffrey Epstein a billionaire? And the answer was no comment. Right now, we don't even have a clear idea of just how wealthy they are. As you may know, the Public Corruption Unit was the one that brought the Jeffrey Epstein case. To what extent is the money trail a big question mark looming around this case, how the money was used and how it was said to have implicated other individuals?
So I want to give two answers, a specific and then a general. The specific answer is that with regard to the prosecution of Ghislaine Maxwell and what this jury is going to be asked to decide, those questions are largely irrelevant. There's a way in which the access that Epstein and Maxwell had to the powerful matters, because it helped allegedly to convince the victims that there was no sense in trying to complain to the authorities because Maxwell and Epstein were connected to people at the highest levels. So any attempt to involve law enforcement would only be met with laughter. But in a much larger sense, the fact that the Public Corruption Unit is the one doing this sex trafficking case, the fact that they've introduced into evidence the infamous Black Book, which has the names of many of the powerful and wealthy and powerful, is an overhang. And one of the things that I, as an experienced prosecutor, would not be surprised to find out is that at some point, if the US Attorney's Office had tried to make a deal with Maxwell to find out who else she could implicate and who she could give hard evidence against, that would not surprise me. If you are a person named in this Black Book, I don't think you're sleeping well right now.
Mm. And on that subject, right before trial, and we'll turn to the actual trial very soon, but right before trial, the judge asked both Maxwell and the prosecutors, were any plea offers extended, requested, or considered? And the answer was no. Does that surprise you? If you were a prosecutor handling this case, given everything that's now on the public record, would you have tried to flip Maxwell on other targets?
The answer to the first question of am I surprised is no, because of the very technical way in which the question was posed. I would expect that they did explore whether or not there was a potential for cooperation, but exploring a potential for cooperation is a long way from making an actual plea offer. And if the response to is the defendant interested in exploring cooperation, which would necessarily entail taking a guilty plea and doing jail time, that would be the first thing that would be said, in my experience, by any prosecutor. And the response from the defendant is, I'm not pleading to anything, I'm not going to jail. That basically ends the conversation. Mm-hmm. So there technically would not be a plea offer that was extended or considered.
That's very insightful. So turning to the trial itself, we're at the end of week one, and I think the biggest piece of testimony that came this week came from the first of the women who are listed in the indictment as minor victim one, and we're talking about Jane here. What jumped out at you about her testimony?
What jumped out at me is that if Jane is believed, this is a very simple case, because Jane alleges not just that Maxwell was part of the grooming process, but that Maxwell physically abused her herself. So it doesn't take any inferential steps for the jury. If they believe Jane, Maxwell is guilty, at least of the counts that involve Jane.
And so, sorry, as you mentioned, Jane had implicated Ghislaine Maxwell directly. It was grueling testimony. The one allegation against Maxwell was that she fondled her breast. There were allegations against Jeffrey Epstein and specifically also against Ghislaine Maxwell, saying that she groomed her, in addition to physically abusing her, groomed her for Jeffrey Epstein's abuse. They, as you noted, if the jury believes her, the prosecution wins. The defense vigorously tried to dispute her testimony by trying to compare what she said on the witness stand with what she told law enforcement. What did you think of their cross-examination?
I thought it was skillfully done, and you fight with the army that you have, not necessarily the army that you would want. I don't think that it's, and I'm not there in person to be able to see the expressions on the faces of the jurors, and that's really the thing that I would want to know the most. But on reading the cold record, I did not think that this was likely to dissuade jurors who had initially concluded that they thought Jane was telling the truth to, oh, she must be lying. And one of the advantages that prosecutors have is when they put on a victim, they go first. And the old adage that first impressions are lasting impressions is absolutely proven science in trials. If the jurors initially believed that they had a truth teller in front of them when Jane was testifying, it takes a lot on cross-examination to make jurors say, oh, I've been hoodwinked. This person isn't telling the truth. This person is lying. And the defense here is not, at least with regard to Jane, that she's mistaken, that she's giving the wrong understanding to innocent behavior by Maxwell. The case here is she has to be lying about Maxwell putting her hands on her private parts. If that's true, everything else follows. Then there is no innocent explanation for a middle-aged woman befriending a 14, 15, 16-year-old girl, often not in the presence of either of her parents. Well, her father was dead at that point, but not in the presence of her mother. There's no explanation for traveling around the country and the world with, well, not around the world, around the country with her. There's no explanation for any of it, because once you believe that Maxwell fondled Jane, then everything else is only consistent with everything Maxwell was doing was to make Jane compliant with the abuse.
And you're absolutely correct. They did not appear in cross-examination to be trying to suggest that there was some sort of innocent misunderstanding. We'll see what happens in closing argument if they try to make that statement, but they seem to be, and we've seen from opening statement, they are trying to put forward a theory that this case is about, in their words, memory, money, and manipulation. And what there was, as onto the hands-on abuse, they claim that the government interview, she said that she couldn't recall whether Maxwell touched her. So as to that statement, do you think that that was damaging? And what will prosecutors say about these notes from interviews and how reliable they are?
Okay, so I think that that was probably the most effective part of cross-examination. And there, the redirect, I thought, was well done. Because what was done on redirect, and for those who don't know, redirect is when the prosecution gets back up and questions a witness after cross-examination to try to explain away some of what's been raised on cross-examination. And on the redirect, they walked Jane through the process of how, when she started being interviewed, it was in a room filled with a lot of people. I don't know if she gave a precise number, but in context, it sounded like upwards of 8 people, and that she was very leery to reveal the most literally intimate secrets of her life in front of that large group of people. And that as time went by, the group of people who were interviewing her slowly decreased. First, there were fewer law enforcement people there. Then eventually even her own attorney wasn't attending. And it was just the core group of prosecutors, and I would imagine the case agent. And then she said she felt much more free to tell the whole truth. In my experience, that is consistent with the way many victims behave. It's going to be up to the jury to decide whether or not the discrepancies between the notes and the testimony indicates a recent fabrication or indicates that she became more comfortable with telling the whole truth. With regard to the notes, the note-taking process is convoluted, and this is by design by the Department of Justice. The Department of Justice, and I forget whether or not this is literally in the Justice Manual, which used to be called the U.S. Attorney's Manual, or it's just something that's handed down orally. You do not make verbatim transcripts of witness interviews. That's like one of the things that you learn as a baby AUSA. You don't have a court reporter there. You don't have a recording device there. You have people who are taking impressionistic notes and trying to take impressionistic notes when people are having a grueling conversation where you can't go say, hey, could you repeat that? I didn't quite get it. Is always inaccurate to some degree. By Jane's testimony, a lot of these notes were highly inaccurate, at least the ones that the defense focused on. My suspicion is that there were dozens and dozens of pages of notes, and the defense, as they should, only focused on the discrepancies that might be 5 or 6 over the course of dozens and dozens of pages. But it was a mantra throughout Jane's testimony that the notes were wrong about that.
Mm. And she did say that a number of times. And I remember precisely the kind of moving testimony that you were referring to, that she said, I was in a room full of strangers disclosing my deepest and darkest secrets, as to the alleged discrepancies brought up by the defense. So I guess this kind of goes to the question of the defense strategy of attacking memory in a case that, at least in Jane's instance, started in 1994. To what extent has it seems like there's a lot of corroboration for important elements of Jane's story that came out in week 1 of trial. Would you agree?
I think there's a lot of corroboration. I think that the testimony of the individual who's only identified as Matt is incredibly important in that regard. Would you like me to explain?
Absolutely. Please do.
So Matt is the ex-boyfriend of Jane. They were together, according to his testimony, for about 8 years. They are apparently co-workers on some TV show. I think it's a soap opera from Context. You know, I have on purpose not tried to figure out who Matt or Jane are. I know that other people know who Matt and Jane are and are honor bound not to reveal their identities. But my point in saying this is these are two people who have an ongoing relationship, but no longer a romantic relationship. And Matt testified, I think, in what had the ring of truth to me, that when the original charges against Epstein came out, she told him not only that she was one of the people who was abused, but that there was a woman who was involved in making her feel more comfortable being at Epstein's house. Matt testified that while Jane would talk in general terms about the fact that she was abused, she wouldn't go into detail about it. And I think given the fact that they had a multi-year sexual relationship themselves, it's not that she was afraid to talk about graphic things with him. Presumably, they had that sort of intimacy. It's that it was too painful for her to recall in detail. And then when Maxwell was arrested, and this is long after Matt and Jane's romantic relationship had ended by Matt's testimony, he contacted Jane and said, is that the woman who you told me about all those years ago? And Jane said, yes. For me, there is no way that Jane in 2009 would have planted an Easter egg that could only come to light a decade later. If she was trying to fabricate things, she would have said back in 2009, Epstein abused me and Maxwell helped him. It seems much more likely to me that what happened was she said to her boyfriend, Epstein abused me. I don't want to get into details. And he asked for details. And one of the details he asked for was, how did anybody leave you alone with a middle-aged man? And her answer was, well, there was this woman who made everybody feel more comfortable that I was spending time alone with him. But she wouldn't or didn't reveal who the woman was. But she knew who it was. And it was so memorable to Matt that more than a decade later, he asked Jane unprompted, hey, is that the woman you told me about all those years ago?
Right. And there were other witnesses who placed Jane physically with with Maxwell and with Epstein, there was Epstein's pilot who testified that she was the girl with the striking powder blue eyes. There was Jeffrey Epstein's former house manager, Juan Alessi, who said that he remembered Jane with Maxwell and Epstein when her mother was not present in the Palm Beach residence. To what extent, we're at week one of trial. It's going to be about 5, 6, maybe more weeks of trial left to go. When the jury gets to the deliberation room, how much are they going to put together these various pieces of the puzzle?
Well, I don't know. And anybody who claims to understand how juries work in specific is either much smarter than me, lying to themselves, or lying to you. But what I do know is that stories matter much more than facts. The famous attorney Jerry Spence put it in a way that I've tried to incorporate into my practice. Facts are not persuasive, stories are. So I don't think that the jurors are likely to be motivated by any particular fact. They will be motivated by the story that they believe, and then they will grab onto the facts that they believe support the story that they've already been convinced of. And there's a lot of good science that shows that is the way human beings make decisions in jury rooms.
And on that note, there's a story that ended week one, which was prosecutors bringing the physical massage table into court, the green massage table where Jane says that she was sexually abused. What is the power of bringing the object into court? Why do prosecutors do that?
Well, this may be apocryphal, but as I was trained, human beings get someplace in the range of 80% of their information visually. And the ability to visualize something is very important to being able to remember it. And it sinking from short-term memory into long-term memory. Putting the massage table in front of the jurors helps to make it more concrete. I would imagine that either the prosecution decided not to go the ultimate step of having Jane lay down on the massage table, or it would have been too traumatic for her. But you want to, as a prosecutor, you want to create that image in the juror's mind that they cannot forget. And the massage table by itself, if I was grading it from A to F, is probably a B- or a B. If the jurors put the massage table together with the person they saw testifying, then it becomes indelible.
And that was, of course, brought into evidence on the last day of the first week of trial. There were other exhibits brought into evidence, including a video of the walkthrough on the raid of Jeffrey Epstein's house in 2005, and proceedings that day began with arguments over how they could bring into evidence, that prosecutors could bring into evidence images that were in Jeffrey Epstein's house, including art and photographs of what appeared to be minor girls. The government won that argument to an extent. There was a instruction for the jury. How much was that an important victory for the government, and how much was that limiting instruction helpful for the defense?
I think that without the limiting, it's not just the limiting instruction, but the images that were kept out from the jury, I think this case would be much closer to over. As I understand it, one of the images that the government wanted to put in front of the jury was a picture that was hanging in one of Maxwell's homes of what was clearly an underage girl in a sexually provocative pose. And if that had come into evidence, and I'm the prosecutor, in my closing, I'm going to talk about how every day Ghislaine Maxwell walked by that and wasn't horrified by it. And what's the natural inference from that? She wasn't horrified by it because she was doing it and she was helping Epstein to do it. That is what the government would have wanted to have argued from that. And the fact that that image was kept out and the teeny tiny cheerleader uniform that was clearly for a not just an underage girl, but probably a prepubescent girl was kept out. People do not understand that pedophiles attack children as young as infants. That is just an image that most people can't process. So even as this jury is considering whether Epstein and Maxwell were attacking 14, 15, 16-year-old girls, keeping out the image that he may have had attractions to 7, 8-year-old girls was, I think, very important.
Mm. And as for the images that were let in, does that undermine, given testimony by Juan Alessi and others that she was a lady of the house, that by the pilot that she was Epstein's number 2, and by Alessi that she was with him, by his estimate, 95% of the time? Does that, forgetting about what Jeffrey Epstein, how he decided to decorate the house, but as you mentioned, how she spent so much time there and presumably saw all of these things.
Yeah, I think even the images that were let in will be argued by the government to show her knowledge and not just acquiescence, but participation in the abuse. Because if you weren't in an abusive household, that's just a really creepy thing to have hanging on the wall. But I don't think it's the most powerful evidence that they could have brought forward. I am certain that we're going to get, over the next weeks of this trial, a drumbeat from the additional victims who testify and the additional corroborating witnesses, things that it becomes very hard for Maxwell to dance through the raindrops. You might be able to explain away one thing. You might even be able to explain away 8 things. But when 8 things becomes 40 things over the course of 5 weeks, it's really hard to say, oh, the natural explanation here, or even a plausible explanation here, is that she was just the innocent dupe and Epstein was doing all these horrible things without her knowing it. That's a hard one to hold on to.
Mm. And as for that very powerful bit of evidence that was left out, can you explain the judge's ruling and the reasoning for keeping that particular photograph out?
I believe, and if I'm wrong about this, please, go past this. But I believe that the problem was, for the prosecution, they couldn't tie her to knowing it was there. In other words, they didn't have anybody who could testify that she saw that image. It was a natural inference, but that image was so inflammatory that the judge thought that it was the equivalent. There are certain things that you can just never let in, even with a limiting instruction, if there's a question as to its veracity. For example, any good judge will not let in an account of a confession if there's a real question about whether or not the confession was actually made or voluntarily given. You can't say, oh, let them hear the confession and then the jury will sort it out whether or not that's real. I think this was at that level of inflammatory.
Mm. And generally speaking, you prosecuted sex trafficking cases. How are the prosecutors doing from your look at the record?
So I think that they are presenting the case in a very straightforward way that is designed to show a shared revulsion with the jurors, as opposed to forcing the jurors to swim in stuff that the jurors will find revolting and might resent the prosecutors for forcing them to confront. It's a balancing act when you're a prosecutor here. I think they clearly know the law very well. They know the facts very well. There's one particular example that I thought was a real swing and a miss by the defense that became a swing and a miss because the prosecution did a great job on redirect. And that was on cross-examination. The defense went through the application for the Interlochen summer camp, which is a music camp for very well-accomplished musicians. And there was a sentence in there that I found very jarring when it was presented on cross-examination, where Jane, in her application, said, I don't find any of it difficult. That was the statement. And it seemed to me that that was inconsistent with her being abused unless she was absolutely, just in the pure denial stage. But that sort, and the questioning made it seem as if the cross-examination made it seem as if the question on the questionnaire was in relation to her family life. And then on redirect, what the prosecutor brought out was the question was actually, talk about a musical piece or composer that you find difficult to work with. And she said, I don't find any of it difficult. And in that context, and then she was even more humanized because Jane's current testimony was, yeah, that had nothing to do with my family life. That had to do with me being a way too cocky kid about my musicianship when I was 14 years old. And I wasn't there, and I haven't seen any reporting on this, but I would imagine that the jurors smiled, laughed, and then looked at the defense table and said, you tried to pull a fast one on us there.
Mm. And in terms of the look ahead, we've heard one from one of 4 women who are listed as minor victims in the indictment. What will be themes to look out for as they continue to take the stand?
I think one of the themes to look out for is Maxwell alleged to have touched these people or merely groomed them? Because grooming, as even the prosecution psychologist testified, grooming is a tag that is put on behavior that might be innocent or might be predatory, depending upon the end result. Giving gifts to underprivileged children can be some of the most wonderful things that anybody will ever do. It can also be part of predation. It really depends on what was it all leading up to. If you have testimony that you have gift giving followed by Maxwell engaging in the abuse herself, so that there can be no question that she was aware that the gifts were luring these children into a horror show, that is something that really doesn't require the jurors to make any inferential leaps. If, on the other hand, the testimony is about grooming and Maxwell being present during things that were maybe over the line, but she wasn't engaging in them, and there's a question about whether or not a child victim would really notice who else was in the room at the time, that requires more of an inferential leap by the jurors. And I think that one of the reasons that the prosecution led with Jane was Jane testified not just that Maxwell was engaged in grooming, but that Maxwell was engaged in hands-on abuse.
And obviously the general public, reporters, and folks who have been following this case for a long time are privy to more information than these jurors who are rightly being kind of shielded from anything that is not evidence before them. One of the ways that the defense has been attacking the witnesses is by talking about the Jeffrey Epstein Victims Compensation Fund. To what extent do you think that it will come out, if I can rephrase this in a certain way, for many, it has taken more than 25 years for a case like this to go to trial. And for many of these women, the Jeffrey Epstein Victims Compensation Fund was the only way that they could seek any sort of accountability. The defense has made a lot of hay about it, and they plan to bring up the fact that every single one of the witnesses has collected large amounts of money from the Jeffrey Epstein Compensation Fund. To what extent do you think the jury will be aware of the context of there not having been criminal prosecution for people in Jeffrey Epstein's circle until now?
I think that that seeps through this entire case, even what's in front of these jurors. I know that the judge has tried to keep the focus on this case and not Epstein, and not why Epstein was given a sweetheart deal in 2009. I think that the defense in their opening statement made a huge swing on the Epstein Compensation Fund. And so far, I have not seen any signs that they're going to be able to deliver on what they promised in their opening. Because what the defense said was that they were going to be able to show that these victims believed that they would get more money by changing their testimony, their accounts, in order to implicate Maxwell. And that is the reason that this should all be taken askance. If they intended to do that with Jane, it didn't happen. There was some attempts to question about what she knew, what her lawyer knew, what her lawyer communicated to the government. And all of that was muddled. There was no aha moment there or anything like that. And from what I can tell, what the defense is hanging their hat on there is in the protocol for the Epstein Victims Compensation Fund. One of the non-exclusive factors that the people administering the fund said they would consider is the extent to which there was corroboration from prosecutors, DAs, FBI agents, AUSAs of abuse. I think it's a big inferential leap to go from that to a systemic thumb on the scale saying you need to change your story to implicate not just Epstein, but also Maxwell to get paid. Because to be blunt about it, the horrific abuser, as far as the physical acts that were done, was Epstein. If Jane was never involved with Maxwell whatsoever, but everything that she said Epstein did to her was true, I know she got $5 million, and I believe that she would have gotten the exact same $5 million if Maxwell was no part of the story. It absolutely defies credulity as far as I'm concerned, or strains credulity. Maybe defies is too strong of a word. It strains credulity to say, hey, the only way that Jane thought she was going to get paid was if she threw Maxwell under the bus along with Epstein. That just doesn't make sense.
When we spoke right before the trial, you had mentioned that one of the challenges that the government might have here is that this is a case that is more than a quarter century in the making, and that began in 1994, the age of the allegations, and how the defense was going to use that to attack memory. How do you think, now that the trial has gone on for a week, how is the government handling that challenge?
I think it is a real challenge. Still think it's the biggest challenge, but I think that again, the redirect by the government of Jane and where they ended was incredibly powerful. And with your permission, I'm going to be very graphic because the testimony was very graphic. Jane was questioned at the end of redirect about when was the first time you ever saw a man's penis? And she said it was when I was 14 years old and I saw Jeffrey Epstein's penis and I was told what to do with it. And then she was asked, well, what were you told to do with it? And she said, well, I was taught how to masturbate him and, you know, how to put my hand around it and what to do. Without saying the words, the message that the prosecution put across was, yes, this is all really old stuff. And yes, Jane may have gotten some of the details mixed up over the years. And it's possible that some of what she's told you today has not aged well. And she's forgotten who was where when on, you know, when she was flying from one place to another. But she's never going to forget the moment that she first saw Jeffrey Epstein's erect penis. And every single juror will be able to identify with that. There is nobody on that jury who's going to say, oh, she's just gotten confused about whether or not that happened. That's something you don't get confused about whether or not it happened.
Thank you very much, Mitch Epner, for coming on the show, and hope we'll keep in touch for more of your insights and analysis as the trial progresses.
Thank you very much.